Hello and welcome to Climb's podcast series Advancing Vietnam with me, Vlad Savin, as your host. Throughout the following episodes, we're looking to answering relevant questions about doing business in Vietnam. What are the opportunities and challenges faced by investors entering the market or existing players in major industries? We will seek to understand the business environment from a cultural, local mindset and how to deal with compliance from an international perspective. What are the major risks faced by businesses active in the region and how to overcome them? We will dive deep into the compliance environment in Vietnam, discussing processes and procedures, changes in laws, latest official updates from the authorities, and financial governance planning for businesses active in Vietnam. We at the Climb consider compliance a major asset for foreign investors operating in Vietnam. We emphasize this aspect when speaking with our clients, and we make sure they understand the significant benefits of being compliant. In this episode, I'm discussing with Matthew Lowry, Managing Partner at Climb Vietnam, about the most important statutory positions in a Vietnamese enterprise, their key roles and responsibilities, and we will cover practical insights on assigning these roles and protecting the risk of investors and the integrity of the investment structure in Vietnam. Matthew, welcome to our new Advancing Vietnam podcast series.
Great to be here again, Vlad.
When establishing an enterprise in Vietnam, one of the most important components in structuring the entity reflects the key roles and positions in the structure. Before we delve into what these are, I'd like to set the foundation for the discussion first and ask, why are these positions important? Does it matter who holds any given position in any given time? And why should investors pay attention to assigning these roles as an integral component of the market entry strategy for Vietnam?
This sort of start, it is one of the more complicated opening parts of looking at a company in Vietnam is what are these roles and responsibilities? They don't quite make sense in a common law context. And the titles and understanding why, what, where. So the fundamentals that I start with is that a company in Vietnam does not have individual capacity. So that unlike a common law company, which has capacity, the directors are signing generally on behalf of the company, but the company can be sued. The company is an enterprise in its own right that has a capacity in its own right. In Vietnam, the capacity doesn't exist with the company. You need to have representatives, legal representative investors. The intention is that an individual needs to have power and is representing and signing. So trying to define what powers these individuals have is what we're ultimately trying to achieve when setting up in the first discussion is that who has which powers, the investor powers, the company powers, and in between there's a few different elements to that. So we're looking at powers because a company does not have the capacity in its own right.
Mm-hmm. And let's start then with the legal representative. Each enterprise in Vietnam needs to have at least one legal representative. What is the standard definition of these roles?
Yeah, so a legal representative is probably the key role in my opinion, even though it is in conjunction with other capacities, it is the party that has the power to operate, to be sued, to start actions against the company. I put it like in a common law jurisdiction, a trust and a trustee, where the trustee exercises and looks after the assets and liabilities of the trust. A legal representative is almost like that. It's not exactly, but it's a good parallel analogy where the legal representative is looking after the assets and liabilities, and if someone wishes to sue the company, they'll sue it through the legal representative. Opening a bank account, the legal representative opens the bank account on behalf of the company. So it has that role of exercising the capacity. What the company needs to do is the legal representative is that legal. You'll see contracts, and you would have seen them many times, where a contract in Vietnam will have company name represented by. Who has the capacity to look after the company? And just as an aside, when a foreign company is being part of a Vietnamese contract, it will say foreign company represented by. Like, why? It's just the directors who can sign. Why does it need to be represented by? That's that Vietnamese concept that a company does not have individual capacity under Vietnamese law. So that's where the legal representative comes in. Now, you need to have at least one resident legal representative. Mm-hmm. There's an unlimited number of legal reps in theory you could have, provided one of them sits in country. And we can talk later about joint and several liability and risks and how that works, but you need to make sure that one of your legal representatives, resides in Vietnam, and if they're out of the country more than 30 days, someone else is required to be in country to have that capacity. So you can't have all legal reps out for more than 30 days or you're in breach of the law. Mm-hmm. And sorry, just on that, any nationality. There's no nationality requirement. It's a residency requirement, not a nationality.
That's right. And going back then to the foreign investor and the investor entity, they also need to have an authorized representative. What is this role?
Yeah, so as in you need a representative. An individual must, in Vietnamese law, have the ability to bind a company. So if your investors are individuals, they're already individuals. If it's a company, the company must nominate a person to represent the investor. So when you're starting the company process, who is representing the investor? Who has capacity of the foreign investor, the foreign company, to sign documents and to bind the investment application and the process in Vietnam? So that authorized representative is sort of bringing a foreign law into a Vietnamese concept that we can work with.
And can they be one and the same person?
No, first that must be separate. So you must have to start the company, you must have two different individuals, one representing the investor and one who will represent the new Vietnamese entity being set up, being the first legal representative. You can have multiple roles we can talk about, but the setup stage, you must have two individuals to do those two different roles, one foreign, one representing the local.
And at the investor level, there is one more key important position in the structure, which is the chairman. It can be the chairman of the company or the chairman of the members' council. Can you explain the chairman's definition and role?
Quite commonly misunderstood, because the chairman, the concept of chairman is chairman of the members' council or chairman of the investors. So it is the role that represents, ultimately long-term, represents that the foreign investor or the investors. So they sit outside the company. That's the oversight. So to keep in mind that your legal representative and the directors we'll talk about shortly sits within the company, and that's the company itself. The investors sit outside. So you have a chairman of the members' council. You can, depending upon the structure you choose, you can have a members' council, which is 3 or more people representing the investors, and they have a chairman. The chairman becomes the authorised representative in most cases. So that they act as that foreign power. You can have a chairman without a members' council, just an individual, particularly if it's a single member investor, that you can have one person, or you can have that council, but that chairman sits outside. They are important because they're the ones who are appointing legal reps and general directors. They're the ones who are signing off on structural changes. They're the ones who are making sure that the investors are protected. It's not a lot of capacity, a lot of roles that it takes, but it's a very key role. And as opposed to legal representative, which is more of a functional role.
Mm-hmm. Before we move to the next important positions within the Vietnamese enterprise, let's understand a bit more about the risks and responsibilities for these positions we talked about, specifically the legal representative, the authorized representative, and potentially the chairman. Where do the risks for these individuals and within the structures lie?
Well, below that legal representative, you then have general director, and they can have multiple capacities. To keep in mind, to put this back on risks and responsibilities, the general director, the directors, and those which operate the company are operational roles. They have a risk if they do things illegal and do things irresponsible, but the company risk, the risk and where if the company's going to be sued, legal representative is that risk. They're the ones who have the risk and responsibilities of in front of the courts, in front of the authorities, responsibilities if things aren't done. And so that's where the risk sits. The chairman doesn't have the level of risk. The chairman is a statutory role. The directors are a functional role. That legal representative is that there. Now, you can be chairman legal rep. You can be general director legal rep. Legal rep is a title. You need to be something to attach to it. Mm-hmm. So that's where the risk can actually sit with chairman if they are legal representative. Mm-hmm. The risk can sit with general director or other directors if they are legal representative. Mm-hmm. So who has the legal powers? And then what is their role in the organisation? Mm-hmm. So there's sort of 2 ways to look at it.
And for the other role you mentioned, general director or director, how does this role get usually assigned by the investor? What is the common approach when entering the market?
So you have one general director, and they are the operating of the business. So legal rep is the legal structural protector. General director runs the business. They have day-to-day capacity, day-to-day power. So general director or director, they are generally, they're appointed by the chairman or the members' council appoints them. And in most cases, the general director is a legal representative because that gives them full power. Not always, you don't have to have that, but that's a common approach. And then below the general director, so the director or general director, below them you'll have deputy directors, deputy general directors, power of attorneys. That's your general operating structure. So the director role does not sit on top of the company, it's within the company, and then there's a layered approach. And so you can have delegated authorities for a finance director, you can have delegated authorities for a HR director. They are reporting to that general director role, and they are the key part to operate and run the company, and they are accountable to the shareholders and for their results.
One of the models that investors choose when entering the market in Vietnam is the so-called nominee structure. What is the danger here? As we have seen many cases of foreign investors registering companies under a Vietnamese individual's name, who becomes in a sense that nominee of the company and the legal rep of the company. And what is the model and what are the risks with this process?
There's a few different parts to that relevant to this discussion. One is the separation between ownership and legal representative director type roles. There is no requirement for vast majority of cases, there's no requirement on nationality for operations. So director, legal rep, the fact that it's locally owned does not require locals to be named as the operations. So that's a misnomer. There may be employment issues and other things that exist, but that we often see those who are using structures, which I don't think necessarily are appropriate in most cases, the idea of that they must be run by Vietnamese and owned by Vietnamese, you separate them, ownership versus operations. Now, let's come back to restrictions of powers and how we can protect that separately, but look at the nominee structure. Fundamentally, there is no law in Vietnam that permits or supports nominees. There's no trust law, there's no nominee law, there's no beneficial ownership. You're a named owner, you're the owner. So this concept of nominee is dangerous because the individual named on there is the owner-in-law. And enforcing that in Vietnam, you can't enforce a nominee agreement because it's not prescribed, it's not permitted. It's not permitted, but there's no structure to permit that, and a court will not enforce. More importantly is that the recent enterprise law changes does give the power to the authorities to deem a clear nominee structure to be invalid and require unwinding that structure. So anyone doing a nominee, there are ways to have a Vietnamese named to get around investment laws whereby you have sufficient protections, you have ability to loan and secure, and there are ways to do that, but this vanilla nominee is just something we would not necessarily do. The risks and limiting those risks with, as I said before, the legal representative is bound, is responsible for the actions of the company in the eyes of the law, and they're representing the investors, representing the company, and therefore the risks and court actions, legalities. The law, when they changed enterprise law recently, they removed this, so they added the concept of joint and several liability, so that if there's more than one legal rep, everyone is bound and equally liable to the law, and in practice they'll go, the resident legal rep will be the one that the courts will go to because that's accessible in Vietnam. You have the ability under the law to change that in the charter, so remove joint and several liability. I'm not aware of any cases which actually go through how valid that is and what the courts will interpret, but in theory you can. But also what we tend to find is that if you've got someone in country acting as legal rep who you don't want to have full capacity, you can restrict in the charter and put the offshore party to have to authorise the onshore. So you can do restrictions on powers in the charter, whether external parties recognise that because they're still named as legal rep. And also you can do contractual. So as part of their contractual appointment by the chairman, by the board, part of their contractual obligations and payments within the charter, you do restrictions. So you can limit the powers so that everyone doesn't have unfettered powers. So you can do that. So there's a liability issue, and joint and several liability, or who's in country, and then also what they can actually exercise and what they can do and playing around. So to come back to, that applies to nominee and non-nominees, but the nominee structure generally, it's ineffective, generally inappropriate, and if you have a Vietnamese named owner for ownership restrictions, does not mean that they have to also be the operations, the general director, legal rep. It's not the case.
And we'll talk a bit more at the end of the discussion about a few case studies on how to assign the legal reps within the structure and what models work best for enterprise in Vietnam. Now, going back on statutory structures, what about the board of supervisors? What does it mean from a statutory perspective?
So you've got board of supervisors, board of inspection controller. They're fundamentally the same thing. They're different roles and different structures, but they're an oversight body that is reporting to the members' council, the members, the chairman, and they have significant powers to investigate and review and look at the business, look at operations. Ultimately, the problem is that their advice and their findings are to be advised to the chairman and the board members' council, but they don't have to be followed. So they can be ignored. So it's sort of a toothless tiger in some ways. Now, in a joint stock company, they have a certain role. So a public company, they have more of an oversight role and they're more important. For a private company, they're less important. And in fact, they're optional for a single member. So how that works and the different titles and different structure, they're there as an oversight, an inspection. They're there to provide governance. Whether they work, yeah, that's a different story, but they exist. The key is not a multi-member company does need to look to make sure they're compliant. A single-member company is much easier because it's an optional element to put in, but a multi-member company, you do have to consider this, even though it may not have any governance benefits for your particular structure. And to come back to your point we'll go into shortly, I expect is that we often like to have an offshore structure owning 100% of a Vietnamese structure, because then you can have a simple, you don't need these inspection committees, and you don't need to have a complicated members council. You can have a chairman, and you can be quite simple in practice, and you can do the complications at the offshore level. So that's a common way we often see these things.
Mm-hmm. Now let's talk about the chief accountant. Even though it's not a specific position, part of the management or the board of the company, it is one of the most important key roles within the company from a process perspective as well, and from a liaison perspective with the authorities. Why do you think chief accountant is one of those key positions in a Vietnamese enterprise?
It's a good point, because Vietnamese companies don't have a company secretary. So the role that in common law we have company secretaries is responsible for governance, the lodgements, the dealing with the authorities. That role doesn't exist. So even though the chief accountant is not specifically replacing that role, quite a number of the functions in practice tend to fall on the chief accountant. As their details are with the authorities will tend to contact them when it comes to compliance and lodgements. They do have to sign all financial documents, accounting documents, tax lodgements, etc. So there are statutory requirements, and you must have a chief accountant appointed. And so it's partly a requirement under law of accounting, and it's partly that they do have that secretarial. So what you do, you tend to find that you lean upon the chief accountant to be that secretary in the context that you would have in a common law country, even though that's not their full position, but that's why that's important. If you don't have a company secretary, you do have issues, because who do they contact? The authorities tend just to not contact, and therefore you might be in breach of certain things without knowing that. So the company may be sort of in the bad list without knowing it, because who are they contacting? Who are they dealing with?
Mm-hmm. Let's look at a couple of practical examples here. Let's imagine a foreign corporation based out of Singapore wants to establish a 100% foreign entity here in Vietnam. How would they choose their structure for the statutory positions? Let's imagine it's a tech firm with 30 employees looking to set up here a subsidiary.
Yeah.
What is the easiest model for them?
Yeah, straightforward, 100% owned limited liability company, one single shareholder out of Singapore. You have a chairman representing the shareholder, the Singapore company, one individual who may be the CEO, maybe the group chairman, but that person who has capacity by the board in Singapore to sign the documents to start the company, and then to lead the company later on. And that is make sure the decisions are passed down, make sure the general director and legal reps are appointed. So the offshore single chairman model. At the Vietnam level, you have a resident legal representative who is also the general director, so an individual resident in Vietnam that exercises the capacity. The chairman will also be a legal representative offshore, so you've got two legal representatives. You've got someone in Vietnam who meets the residency requirement and is also the director to operate the business. So simple structure, no inspection committee or controller. You just have that simple structure. And then you have a chief accountant, which you can external appointment or internal, you can outsource or you can employ your own. And in that case, you've got a relatively straightforward structure. You don't have complications. You don't have to have members' council meetings. You don't have to have a lot of those issues that arise if you make it more complicated. That is really unnecessary in practice.
Right. Now let's try to figure out a bit more complicated case. Let's imagine there's 3 investors in Europe, 2 corporate investors investing in, let's say, agriculture, and 1 individual. They're looking to enter Vietnam to set up a subsidiary here. 33% each of the structure in Vietnam. They're looking to set up their specific statutory positions. How would they assign their roles at that level?
It depends on a number of factors here. So first of all, agriculture is a difficult business because of restrictions, but okay, I'll take it. Agricultural trading, okay, we've got a structure. They could do a number of things. One is they can come in directly. They can set up as the shareholders or members in a limited liability company. There will be members' council. They can each have a role at members' council. They would appoint one person as chairman, and there may be specific roles that they take within that, and you can specify certain roles and what members' council and what they do. In the company, again, depending upon who is here, who is operating it, who has that capacity, you would need to work out how many legal reps you need. Whether all three investors want to have a legal representative, or whether just the resident individual, and what are the responsibilities of each if there's more than one, and you can specify it in the charter. The issue comes down to with that is that a shareholders agreement, a members agreement, is difficult to enforce if there's some dispute. So that's not my role, that's your role, I wanted to do this. That resolving disputes at the Vietnamese investor level is quite difficult, and it can be done, but it's time consuming. The courts are not fast. You can't get a simple injunction. It's not an easy process. The alternate is to set up a holdco, which is what probably the most common, to be honest, is that you have a Singapore, as you mentioned before, holding company that owns 100% of Vietnam, very simple structure into Vietnam, and you do your shareholders agreement, the powers, responsibilities at that Singapore level. You do a shareholders agreement in Singapore, which is much easier to enforce in a court, much easier to get an injunction, much easier to deal with.
And offers much more flexibility within the Singapore for the shareholders.
And you could then raise money, sell the shares, do various things. Someone could be diluted. You can have a whole range of preemptive rights, of non-voting shares. You can do a whole range of things Singapore level. With Vietnam, you don't have the capacity to do so. Vietnam is much more simple or blunt ownership structure. So you could do it at Vietnam, but you've got a lot more restrictions and a lot more complications. If you do it at an offshore holdco level, you get a lot more flexibility. So, for example, if you wish to change the responsibilities, the charter, you need to lodge with registered authority, change of charter. If you want to change the investors at the Vietnam level, you need to apply and go through and potentially do capital injections and go through the process, because it needs to be approved and registered. It's not just a notification. In Singapore, you can do that with a notification, and it's much, much faster and a lot less issues. And even for capital transfers in Singapore, don't require tax clearance or tax implications. Vietnam, you've got a tax implication, but each of those you do as well. So that's what we would tend to sort of see in practice.
And to finalize the discussion, based on your experience with the helping investors entering the market in Vietnam, from a statutory perspective, what will be the most efficient and the simplest approach for them to assign the roles within any given type of structure, even if it's a JV or it's a single member LLC? What would be those key positions that they need to really pay attention to and make sure they assign them, and then all the rest kind of falling back in place?
Yeah, I come back to the legal representative of knowing who it is, capacity and restriction. So that you've got someone who is trusted, you've got your charter. If you've got an offshore and an onshore legal rep, which is, we generally recommend 2 stamps, 2 legal reps. That way the parent company has capacity, can do things, their subsidiary is not just running by itself, they've got control, and they can appoint a new legal rep. So if the Vietnamese resident legal rep had an issue, they've got capacity to appoint someone else. So normally we'll see offshore and onshore. The onshore may have the general director role, operate, and have restricted capacities depending upon the authorities, and the offshore has chairman, legal rep, has a stamp, and has authority to do things. So you've got that control, you've got that governance, you've got that structure. That's it with a single member. That's the most preferred. We tend not to worry too much about the effective board in Vietnam. So director, deputy general directors, power of attorneys. We can assign authorities. You can do power of attorneys, you can assign authorities. That's an internal delegation, that's an internal structure. We tend to worry less about the formalities of that, and it's more about that general director, legal rep, resident, and that chairman, legal rep, non-resident as the 2 key parts to make it work, and just get that charter dialed in regarding responsibilities and the corporate appointment documents, the contract with the resident legal reps, to make sure that the powers are clear and known.
Matthew, thank you again for your practical insights on this matter.
Thank you very much. Great to talk.
To achieve a secure and compliant entity structure with an efficient capital control, we advise international investors to consider choosing an efficient and tailored corporate structure model, as well as plan for having the right management personnel accordingly. Thank you. And many thanks to you, our listeners, for tuning into Advancing Vietnam podcast series. For more information about this topic, please check out our publications on vietnam.acline.com. And if you want to reach out to us for any additional details, feel free to contact me on LinkedIn or throughout the website contact details.